In Nick Sandmann news, a libel lawsuit against the New York Times that had been filed by Nick Sandmann had been dismissed, and the Sixth Circuit has confirmed. So you'll remember Nick Sandmann as the Catholic kid who wore the red Make America Great Again hat in D.C. as the Native American fellow had his drum and beating on it and walked up to him, and there was that famous confrontation. Nick Sandmann was sort of taken all over the press and everything. Well, obviously he tried to sue, and a lot of those cases were dismissed. So today, the Sixth Circuit has confirmed the dismissal of the lawsuit by Nick Sandmann, so he will not be able to recover against the New York Times and others. Let's go ahead and get started with this. From the court's decision on January the 18th of 2019, a then 16-year-old Nicholas Sandmann and his classmates had an interaction with a Native American man named Nathan Phillips by the Lincoln Memorial in Washington, D.C. Video of the incident went viral, and national news organizations, including 5 of the defendants, published stories about the day's events and the ensuing public reaction. Sandmann sues, alleging that the appellee's reporting, which included statements from Phillips about the encounter, was defamatory. We agree with the district that the challenge statements were ones of opinion, not fact, and therefore are not actionable, so Nicholas Sandmann cannot recover. Videos of the confrontation between the white male teenager in the Make America Great Again hat and the elderly Native American man went super viral on media. National media, including the 5 news organizations, covered the incident at length. They sure did over the next few days, with most outlets quoting the statement from Phillips made to the Washington Post. So here is what Phillips said, quote, "It was getting ugly. I was thinking, I've got to find myself an exit out of the situation and finish my song at the Lincoln Memorial. I was starting to go that way, and the guy in the hat stood in my way, and we were at an impasse. He just blocked my way and wouldn't allow me to retreat." The statements and others like it asserting that Sandmann blocked Phillips are referred to as blocking statements. And I think that's an unfair characterization because Nicholas Sandmann was already standing there and simply refused to move, which he doesn't have to move. He was in the space first. And so, he could stand there and the guy could walk around him, and he didn't want to do that. So there was this weird confrontation. So as to the defamation, whether a statement qualifies for protection under constitutional pure privilege is a legal question to be decided by the court, not a question by the jury. Yes. So whether it is fundamentally a statement of fact or opinion is a legal question. The First Amendment protects statements that cannot be reasonably interpreted as stating actual facts about the individual in recognition of an amendment's vital guarantee of free debate. In other words, a defamation claim exists only where a reasonable fact finder could conclude the challenge statement constitutes an actually objectifiable, verifiable fact. Kentucky law, which is the law that was controlling for this purpose, protects opinion statements from having defamatory meaning, but adopts the second restatement of torts approach to distinguish between a pure opinion and a mixed opinion. Pure opinion is absolutely privileged based on disclosed facts or facts known or assumed by both parties. The restatement expresses that a pure opinion may be ostensibly in the form of a factual statement if it's clear from the context of making not asserting a fact, but only a personal comment. So this whole idea is something we've discussed before, right? Just because something is stated as a fact doesn't necessarily mean it's understood as a fact, and vice versa, right? This is to prevent people from trying to be too cute. Like, in my opinion, X, when it's really a statement of fact. So yes, just because something is something that is superficially a statement of opinion is not an opinion. Something that's superficially a statement of fact may not be a fact either. So whether it's understood as a statement of fact is to be understood from the entire context of the thing, which is how we normally do this. The parties agree that because Kentucky has rejected the doctrine of neutral reportage, a newspaper may still be liable for quoting a newsworthy statement of third parties. So this is an exception some jurisdictions have said, right? If the newspaper simply reports what a person said, even if that's defamatory, they aren't responsible. But Kentucky hasn't adopted that, nor have many other jurisdictions, right? So a newspaper can be sued for republishing a defamatory statement of another, even if it's an accurate report of what the person said. Simply saying person X said doesn't necessarily get you off the hook in Kentucky. Some states disagree on this. The opinion versus fact inquiry thus involves 2 steps under Kentucky law. First, the court determines whether the statement is fact or opinion. If the statement is fact, analysis ends there. The statement is considered culpable of defamatory meaning. But if the statement is opinion, the court then determines whether that opinion is based on undisclosed facts. So if you give an opinion, are you also giving all the facts, or are you hiding facts? So are all the facts known or not? If so, the statement is culpable of defamatory meaning, if not protected. Here, the district court held that the blocking statements did not imply the existence of any non-disclosed facts, and Sandmann does not challenge that aspect of the holding. So he isn't saying that Phillips is communicating facts other than what are known. He's simply saying that the facts he's reporting a fact, but he's not saying there's hidden facts. All right. So if the blocking statements are opinion, then they're protected. The way the statement is presented or worded affects the ultimate determination. For example, loose or figurative language can negate the impression a statement was seriously maintaining assertion of fact. So just because you indicate it's a fact, if the overall context indicates you're joking, then the overall context makes it clear that it's a joke. So as always, defamation is understood by its context. The general tenor of the article can also perform the same purpose. Kentucky courts have found that statements to be opinion when those statements were couched in qualifying terms, so sufficiently subjective or clearly indicate to be opinion when evidenced from the totality of the context. The inquiry is specific. A statement that may be capable of objective verification in some context does not mean it's objectively verifiable in every context. So the exact same words might be objectively verifiable and therefore a statement of fact, but in a different context might be a statement of opinion. So as always, the context matters, right? The context matters. It's not merely the words that were used, it's other words in the entire situation to understand what is the meaning behind these particular words. There is no bright line rule that the statements based on sensory perceptions are necessarily factual. Starting with Phillips' statement to the Washington Post, he explained his goal was to find an exit out of the situation. Having articulated the aim, he then describes himself and Sandmann as an impasse, a term that can be literal or figurative. Then, based on Phillips' perception of Sandmann's reaction to his attempt to leave the area, he said that Sandmann blocked him and would not allow him to retreat. Whether or not the video shows Phillips attempting to move around or away from Sandmann or obtain any active movement does not necessarily help us ascertain or objectively verify whether the statements accurately interpret Sandmann's actions as purposely preventing passage away from the crowd or refusing to approve his exit. And retreat need not literally mean to move backwards. The words can also mean to withdraw or back down figuratively. So the court thinks in the overall context, this is opinion. As the district court noticed, Sandmann and Phillips never spoke to each other during the encounter. It's unclear whether Sandmann knew the students behind him stepped aside as Phillips approached, which made him the single person standing between Phillips and the memorial, or whether Phillips knew that Sandmann might have been unaware of the fact. The lack of clarity as to Sandmann's understanding of the situation made the blocking statements all the more subjective in nature. Based on the fact that Sandmann stood in Phillips' way, Phillips felt that he was blocking him and not allowing his retreat. There's no way to determine whether Sandmann's intent from the videos of the encounter, which makes approximate the information available when Phillips made the blocking statement. Here, video shows Phillips walking forward in a crowded area, multiple people moving out his path, and Sandmann standing in front of Phillips. But whether Sandmann blocked Phillips, did not allow him to retreat, or decided that he would not move aside and position himself so that stop Phillips are all dependent on the perspective of the viewer and not susceptible to being proven true or false under the circumstance. There's no core of objective evidence that allows us to determine Sandmann's intentions during the encounter. Moreover, statements appeared in stories that provide multiple versions and descriptions of the events, putting a reasonable reader on notice that Phillips' statements were merely one perspective among many. The online articles that issue embed or link to some version of the video, effectively disclosing the facts upon which the opinion was based. So the idea being that, the video itself provides context from which you can determine whether or not you can determine it for yourself, whether or not he's blocking or not, because the video is objective evidence. So you can determine the truth or not in your own determination. So that everything is revealed to you. So you can determine whether it's true or not. And so there's no, independent harm there. Readers were able to determine for themselves whether they interpret the encounter as Sandmann deciding to block Phillips, positioning himself to stop him, or not allowing him to retreat. As the print articles also presented Phillips' statements in a way, clearly framed his statements as his own perspective of the incident. One newspaper, for instance, explained that accounts of the episode vary wildly, and the question of each party's content has been hotly contested, and the initial video alone only tells part of the story. The article then recounted the encounter in detail and provided accounts from both Sandmann and Phillips. The two other print articles did not even include the alleged defamatory statements only Philip's statement that he tried to walk away. Thus, that brings us to the end of Nicholas Sandmann's journey on the whole thing, as he loses his ability to sue the New York Times and several other newspaper publications that had republished Jack Phillips' statements saying that Nicholas Sandmann had blocked the path. The court finds that in overall context, this is a statement of opinion, and also to the extent it was included in online articles, included the video itself, from which you could form your own belief as to whether or not he was blocking or not. So they find on the overall context, this is not a statement of fact. A 2-to-1 opinion, so at least one judge disagrees, but that is the determination of the Sixth Court of Appeals, and that from the moment brings us end discussion of this story.